Good afternoon and welcome to the October Conveyancing Forum for Northern Ireland. My name is Robert Kelly from Stewart Title, and as always we're joined and led by Ian Quayle.
Hi Robert, how are you?
I'm suffering from man flu, as I was telling Natasha earlier.
I thought I could tell that. So have you been drinking out of wet glasses again? That tends to be what causes cold and flu.
No, I think what it was, I did some training last week for lawyers, and they were generally, as you know, unhygienic bunch, so I think that's probably where I caught it from, but I'll survive through. But thank you all for attending today. We're really excited by the response we're getting to these forums. Really want you to know about the products, and Ian will be talking, and has got a full programme of topics to talk about. But just very quickly, I just wanted to talk about what Stewart Title can do for you in your day-to-day work. So Ian, I think you're in control of the slides.
I am, yeah.
And so there are my details and Ian's. First slide here, just explaining about Stewart Title's online solution system, which does cover properties in Northern Ireland. Very brief details there of the main points, up to £20 million for some cover. Otherwise, it's £3 million for residential, £5 million for commercial. Great thing about this, those are all available online, self-issue. You're in control from start to finish. All of our policies contain 10% inflation cover for each of the first 10 years. So if you take out a policy today for £250,000, at the end of 10 years, it's worth £500,000. Very simple system to get a quote, as we'll look at in a second. If you'll go above those levels, or if the problem you're looking at involves a development angle or something more complex, you can immediately refer it to our underwriting team for a bespoke quote. And also just a note there that as well as the online system, as well as sponsoring these forums with Ian, we do offer other training and forums for people. Very happy to do training for you. And in fact, I'm just at the moment looking at working out what we're going to be doing, working with the Belfast Solicitors Association at the end of November. So we'll be doing some training with them. But if you or your team are interested in any training on products or on how the system works, we're very happy to do that. If you do the next slide, Ian. Just wanted to show you very quickly how Stewart Solution works. You input your property details, and then the next screen, you can search for products. You can either do that by showing all products, by starting to type in the search box, you can see there the problem you're looking for, and solutions will come down, or you can download, click on the most ordered residential policies. Despite the fact that there are well over 100 different risks on the system, as you'll know, there tend to be about 10 or 15 risks that you're looking at on a regular basis, so you can draw those down straight away. If we go to the next slide, Ian. Once you've chosen the risk you're looking for and the level of cover, the system then allows you to answer some assumptions and statements of fact. These are now flexible, so we allow you to change some answers in there. So, for instance, if the property had only been constructed and used for less than 12 months, you can answer that in there. So you remain in control. You can, to a certain degree, bespoke the policy for your client's needs. And then once you've answered all of those, Ian, if you go to the next slide. Once you've answered them all, you click get a quote, and then you get a quote through straight away. They literally a process there of less than 60 seconds from start to finish. Once you've got that quote, you can download a draft policy. You can email the quote to your case management system or to lenders or to the other side who may want to see it. And then you remain in control. When you need to issue the policy, you go in and you enter the commencement date at the bottom box there. The policies remain live on the system for 6 months, so you can go in anytime in that period and issue it. And most policies can be backdated up to 30 days. So if you have a completion day from hell, as often happens, you can go back in the next week slightly more calmly and still issue your policy. Next slide, Ian. So that's very brief. I kept it brief because I know Ian has lots to talk about. But if you are interested in more details on Stewart Solution, there is the email address for it. If you've got any more queries about how we can help you in Northern Ireland, my details on there. If you or your colleagues are dealing with any property matters in the rest of the UK, then contact us on our BD email address there. And if you are interested in any training, either for your firm or for any associations that you work with, that you'd like some training, get in contact with me there. And Ian, over to you.
Thanks very much, Robert. Thank you. Appreciate your help. A massive thank you to Stewart Title for organising these events. If you are using Stewart Title for your title indemnity insurance, it's worth speaking to Robert about the points you just mentioned. A, training with regard to compliance, and B, the fact that there's an online facility and bespoke policies that Robert and his colleagues can obtain for you and talk to you about. And the other thing is, if you are not an existing customer of Stewart Title and use another provider, it's not a question of having to sign a contract or anything with Stewart Title. I'm sure, Robert, you'll correct me if I'm wrong, but if it's just a one-off, say, bespoke commercial policy that your firm requires, or an unusual bespoke policy with regard to a residential transaction, speak to Robert or his colleagues, or drop Robert or any of the team a line at the email address is shown, and I'm sure they'll endeavour to assist wherever possible. So a fantastic resource, great organisation with really good products, competitively priced, and the important thing is a team. And Robert, I was just thinking over the weekend, how many underwriters do you now have?
We've added another 8 this year, so we now have just shy of 20 underwriters.
Yeah.
And of those, about 5 or 6 actually have experience with Northern Ireland property matters.
Right, so there won't be much that they haven't seen with regard to defective title insurance in the context of the Northern Irish jurisdiction.
I don't think so. And of course, one of the things of being this side of the fence, like you, I used to be a lawyer. We see everything we see is a claim or potential claim.
Yeah.
So we do get far more knowledge of these things. So whilst for you as a lawyer, it may be a unique problem, actually, probably we've seen it before, and a bit like these forums here, probably some of your colleagues have seen it before as well. So we're always happy to give advice there and help you if something comes up and you're just interested in whether insurance is available or might be useful for your clients.
Fantastic. Thanks very much for that, Robert. Thank you, and I hope you get well soon. Anyway, right topics. Before I start, this is your forum. So again, we've got a wealth of experienced lawyers listening in today. So if you have any sort of burning issues or questions or particular problems on files that you or a colleague have identified or are currently dealing with, share via the chat facility. We can put your microphones on if need be, but putting a question or query in the chat or putting a topic in the chat for discussion will get the ball rolling. But while we're waiting for that, what I have done is listed some topics that I'd like to talk about. And the first one is artificial intelligence, and a few things here. First of all, more and more you're seeing clients using AI to check what you're reporting on or what you're saying in a retainer or report on title. So, whether you like it or not, artificial intelligence is being used by clients to sort of mark our homework, which is to an extent disconcerting. Secondly, as far as the use of artificial intelligence is concerned, you've got a sort of spectrum of usage and a spectrum of opinions concerning that usage. So let's just look at things right at the very beginning. What we're seeing at the moment with regard to AI is its use in connection with problem solving, and its use with regard to a library of information, the internet, being produced, being accessed to produce answers to questions. As far as the use of the internet, the library concept, that's well known, well versed, and well used. So there's nothing new there. The idea of problem solving, the idea of artificial intelligence actually taking over our work with regard to the conveyancing process is really interesting. And I would recommend, if you're in this field or looking at this field, to read some books written by a guy called Professor Richard Susskind, who is probably the world leading expert on the impact of artificial intelligence on the law. He advises the US government, he advises the British government, and I came across him on the basis he'd done some training for the Judicial Studies Board on the use of artificial intelligence as far as the judiciary was concerned. And the interesting thing about Richard is he says a number of things. One, yes, you should be concerned about what AI can do, but as far as professions are concerned, artificial intelligence will take work from us, it will also pivot the work that we are doing or will be doing in the future. And on that point of pivoting, what he's saying is that the lawyer of today, the newly qualified lawyer of today, in addition to generating legal training with regard to the traditional topics that you and I experienced back in the day, he's also of the view that the new lawyers should be sort of legal technologists, so they should know how technology works and where and how technology will work in the future, and how it will aid and assist the work that we're doing. So his first point is, as well as being a lawyer, you need to have some experience and training of legal technology. And as far as firms are concerned, firms of a certain size will have legal technologists employed. Point number one. Point number two, because of the amount of resource that needs to be spent on artificial intelligence, on this legal technology, he's firmly of the view that what we'll see in the future is more and more collaboration with residential conveyancing firms and commercial property firms, so that they're not reinventing the wheel or going along and investigating the use of AI or adopting AI in connection with the work that they're doing. So the idea is, because you've got the amount of expense being incurred, the amount of technology that needs to be harnessed, you're going to see more and more associations, more and more groups of conveyancers getting together and creating systems and processes, creating documentation, reviewing documentation, and using AI for that purpose. The next thing that he sees is, for the next sort of 3 to 5 years perhaps, AI being used better than it is at the moment, but doing a similar thing to what it's doing at the moment, assisting us with regard to the existing conveyancing process, preparing reports on title, preparing the retainer, indicating to us issues that have been missed during the conveyancing process, or issues or risks that have been identified that needs to be explained to the client. So being, in essence, and put simply and rather naively, the sort of better qualified, more experienced lawyer that we're currently using, but technology sitting in our computer rather than Fred or Enid in the next office to us. So this idea about spotting issues, spotting problems, is something that it will do and will be able to do. Is doing to an extent, but will be able to do more later in the near future. But then what he also says is artificial intelligence should eventually change the conveyancing process so it is radically different to what it is today. And the analogy that he uses is really interesting. He said, let's look at self-driving motor cars. Okay, there are self-driving motor cars you can hire or utilize in the west coast of the USA. And what he said was, the obvious thing to do was to create a robot that sat in the driving seat and drove the car. Okay, so that would be the sort of the way forward that we're perhaps seeing with regard to conveyancing and AI at the moment. The existing process stays the same, but artificial intelligence is a different way of delivering the same process. But what he says is, with regard to self-driving cars, is that's not the way technology has gone. It's the car that drives itself, and it certainly doesn't need a driver, and it certainly doesn't need a robot to drive. So he sees that as sort of the next level with regard to artificial intelligence and conveyancing. So if we're looking at that and dividing up the use of AI into two things, currently, don't know whether you do this at the moment, but AI can assist you in the production of a report on title, can actually produce a report on title for you. And there are a number of companies out there, search companies in particular, that have artificial technology populating reports on title for you. Okay, that's very much first stage AI, using the internet as a library and resource, AI extracting key features of that library and putting it into a format, putting it into a use that you and I derive benefit from. As far as that's concerned, Richard's view is that will get better. Okay, so our reluctance to use AI, the need for us to cross-check what our AI is generating and doing, it will get better and better so that there is less need to cross-check and look at source documents to see that AI is doing what it ought to be doing. As far as the next stage of AI is concerned, this idea about AI actually thinking, and I think that's really ChatGPT version 6 and 7, who knows where that goes. But what he says is, again, look at analogies from the profession. When I first hit the idea of surgeons and surgery, the issue there was, let's create robots that can perform surgery that a human is currently performing. Okay? And what he now says is AI has gone way beyond that and looking at what can be done to make sure that surgery isn't required or the need for surgeons is reduced hugely. So let's use AI to create dietary plans for humans so that risks associated with that require surgery for mitigation or risk removal are eliminated or mitigated again. So that's what he's talking about. Now, before I go any further, on Thursday this week, I think in the afternoon, we've got a webinar with Professor Richard Susskind and myself talking about conveyancing, sponsored by Stewart Title. You're more than welcome to come along. We've got hundreds and hundreds of people interested in attending. I would say attend. Richard Susskind is fantastic explaining how AI works. He's also brilliant at looking at the risks and dangers, but also indicating its use. And I think the important thing here is his view is that AI 6 and ChatGPT version 6 and 7, the use of AI to sort of modify processes or completely rethink processes isn't that far away. And as far as current AI is concerned, it will get more and more sophisticated and thus more and more useful for us in connection with our conveyancing role. If you want details about that webinar, which is free, sponsored by Stewart Title, contact Robert or contact myself and we'll make sure that you come along. The plan then is to do some webinars on how AI actually should be used, compliance issues, etc. But that's for the future. So that was the first thing I wanted to talk about. So I'm going to ask people, Eamon, Helen, anybody else that's attending today, David, anybody else, are you using AI at the moment? Thanks, Robert. Yeah, 2 p.m. on Thursday, and Robert's got details. Thanks for that, Robert. I couldn't remember the timing for it, so thanks very much. Anyone currently using AI? Put in the chat whether you are or you're not. I'd be interested to see that. And I'm seeing it being used. I'm seeing it being used in connection with retainer and report on title at the moment. And I'm seeing it particularly being used in the report on title and AI being used to search the web to find information that can go into the report. I'm also seeing a very unsophisticated version of AI. I don't even think it really is AI, to be honest, being used to migrate data and information from searches into reports on title. If you are interested in any of that, have a look at what search companies are doing, because there's product out there that you could use. Thanks, Natasha. She's putting details in the chat about anyone that wants to attend. And also be aware that what most forms of electronic reports on title are doing at the moment is they're saying, this is what AI says you should be putting in your report, and here's the source document, here's the lease, here's the search, here's the title that AI has used to extract that information. So the thinking that most companies that are producing reports on title at the moment are thinking about is that you as a solicitor, conveyancer, or indeed the client don't trust AI sufficiently to enable it just to produce a report on title and say, there you go. So everything that I've seen currently says that's what AI, that's what this report on title should look like. And if you look at the restrictive covenant that AI has reported on, that's the conveyance in which that covenant is contained, so that you as a lawyer can check and say, well, yes, that interpretation of that restrictive covenant is correct, or I'm not happy with it. So I think that's how it's being used at the moment. I have to say, I've encountered some people who've been very resistant to its use. I've seen others who you'd think would be very resistant to its use actually welcome it and using it. And again, I'm immediately thinking there of someone who basically is a very experienced lawyer who deals with all his own transactions, onboards the clients himself, etc., etc., etc. And significantly, I would have thought if he was faced with there's an AI product for you to use in connection with reporting on title, I would have imagined him immediately saying, no use for me, I don't want to use it. His reaction was, surprisingly, I do want to use it. Why? I'm a very experienced conveyancer. I think I know what I'm doing, but I'm worried I could miss something or make a mistake. Therefore, anything that I can buy into, anything that anyone can provide for me that means the chances of making a mistake or missing something are reduced, I'm going to welcome and I'm going to embrace. So again, I'll ask Richard, Mark, anybody else, are you using AI at the moment? Or have you got policies and procedures on board for its adoption? Are you maintaining a watching brief relating to it? Richard Susskind's written about 3 books on AI, all very interesting. There is a book being published by Thomson Reuters at the moment about AI and the law, which looks at more of the compliance sort of issues. One of the issues, of course, is if you are using AI, are you not allowing your data, client data, to go to a third party to be utilized? And what are the compliance issues with regard to that, client confidentiality issues, etc., etc. So there are some compliance issues relating to the use of AI in its current form, and of course there'll be compliance issues down the road. Okay, next thing I want to talk about is assessing risk when onboarding residential clients. And again, more and more, this is an issue, and it worries me about residential conveyancing and indeed commercial property transactions, that more and more we're doing tasks that aren't driving the deal forward, but in fact are required because of our professional bodies requiring us to deal with it. And it's one of the things that I've seen with all the professional organizations, all the professional bodies seem to be really going at solicitors and conveyancers with regard to failure to assess risk, failure to have procedures and policies in place, and being punished, and certainly as far as the Law Society of England and Wales is concerned, severely punished for non-compliance, even though that non-compliance hasn't led to criminality or hasn't led to anything. So it hasn't, it's not a case of the police investigating criminal activity, then sort of tracing back which firm of lawyers were used, then the professional body then saying, right, that professional body hasn't got policies or procedures that are currently compliant or has them, but isn't applying it to individual files. It's professional bodies coming into firms and saying, your policy is not correct, or you're not applying your policy to files and your staff aren't being properly supervised, etc., etc. And I'm seeing law firms being fined huge amounts of money in those circumstances. I can well understand people being fined where there's been some loss or been some criminality that could have been prevented as a consequence of breach. But the fact that there's a breach and the only way that breach has been identified is by an inspection or by self-reporting, in my view, is very unfair. So, to cut to the chase, assessing risk. Your firm should have firm-wide risk assessment policies. Everyone in the firm should be aware of them, including paralegals, support staff, locums, etc. Again, this is a message from professional bodies. All well and good having procedures and policies, reviewing procedures and policies. Show us that you're applying those policies and procedures to files. Show us that you are ensuring that every firm or everyone that's client facing is aware of those policies and applying them. So the fact you've got a locum in because you've got a conveyancer off work due to ill health, the fact that you've got a receptionist who is onboarding clients or allowing clients to be introduced to the firm before a fee earner gets involved. It's these types of individuals that you need to make sure are aware of policies and procedures. On the issue of assessing risk, just recently I did some consultancy work for a firm that had 6 branch offices, and it had 6 different forms of retainer and 6 different forms of reporting on title, each used separately and independently by their officers. And I was asked to have a look at this, and the first thing I said is you can't do this. You have to have a standardized retainer, a standardized report on title for everyone in the firm to use. And it got even more worrying when I started looking at the work that each branch office was doing. There were fee earners within the branch office that had a variation of the retainer or the report on title. So in essence, when we concluded the work, there were nearly 30 forms of reports on title that firm were utilizing. Well, that's madness. How can you have a policy or policies with regard to assessing risk when your documentation is so inconsistent? When we're assessing risk, what we've got to do is we've got to look at money laundering risks, we've got to look at client risks and matter risks. And again, we've got to assess risk at the start of the transaction, and we've got to review that risk as the transaction progresses and as it continues. One of the things that really worries me about AML risks are risks where enhanced due diligence is required, or where clients are in a sort of high risk category, because in those circumstances it might be necessary not only to undertake source of funds checks but also sources of wealth checks. And sources of wealth checks terrify me, on the basis that what you're expected to do is to assess whether the client, given the client's history, employment history, social background, etc., would be the sort of client that would have the funds to facilitate this transaction. Source of funds, all right, it's a paper chase. It's going back, it's chasing the money down to where it originated. But sources of wealth, I think, is damn nigh impossible for anyone to perform. And certainly the amount of cost that could be incurred, the amount of time and energy required is just extortionate. There are companies now that are set up to undertake sources of wealth checks on your behalf with regard to clients, high-risk clients in high-risk transactions. As far as the matter is concerned, we've got to think about jurisdictional issues, third parties that are participating in that transaction, and the transaction itself. What sort of risk is it? And if we are determining that this is high or medium risk as opposed to low risk, what additional steps and measures are we putting in place? So our professional bodies are not saying if it's high risk, don't act. What they're saying is if it is high risk, determine its status and put policies and procedures in place given its high risk to try and eradicate or mitigate against that risk. And the obvious thing here is supervision, additional third-party or management checks on the transaction, allocating transactions to fee earners that have the appropriate expertise relating to the matter. So it's that sort of thing that I think is important. So A, do you have a firm-wide risk assessment policy or policies? Answer hopefully is an emphatic yes. 2, is everyone that ought to be aware of those policies aware of them? Have they got training and have you got proof? If a professional body came into your office next week or 2 weeks' time and asked to speak to a fee earner, a receptionist, a paralegal or a locum, would they be able to recall what the policy is and then point to a file or a case management system to say, I am aware of the policies and here is a file that proves on each and every file I have applied those policies and procedures? When we talk about fraud or when we talk about money laundering, there's some sort of particular things that I think you need to be aware of. 1, residential conveyancing is regarded as high risk. 2, be careful about client transfers from one department to another. So a sophisticated fraudster might embed themselves with regard to your private client team, creating wills, deeds of trust, etc., or your commercial team, advice on company acquisition, share acquisition, whatever it might be, in the hope that that relationship, that cementing of a friendship, in inverted commas, would then mean that when someone in the commercial or private client team recommends the client across to you in the resi team, you're not going to have a deeper or harder look at the client as you would normally if it was entirely new to the firm. So again, be careful with regard to that. And again, be careful to ask questions about why a client has chosen your firm with regard to this particular transaction. And all of this really is incorporated into the sort of widest theme of knowing your client. Assess risk when we're onboarding the client, assess risk as the transaction progresses. High-risk transactions show steps and measures in place to regulate, manage, and mitigate against the risks that you've identified. No one's put anything in the chat room with regard to topics as yet, so I'm going to press on. And what I want to do now is talk about boundary issues with regard to residential conveyancing and to share with you some useful websites. The RICS has these professional standards with regard to boundary disputes, etc. It's worth having a look at. And a website called Property Protocols has a boundary dispute protocol that is of general application, and certainly I would maintain is useful for you in Northern Ireland and indeed lawyers in Scotland, particularly where you're dealing with rural properties. The problem with regard to boundaries in a conveyancing transaction is this. As far as clients are concerned, clients will be astounded to note that as part of the conveyancing process, you are generally going to be unable to identify legal boundaries. The client will want to know where their rear garden starts and finishes, will want to know if there's a problem with a neighbour, where the boundary fence should be or a boundary wall should be. From a lawyer's perspective, what we've got to do is try and ascertain what was intended when the boundary was created, and that can be a really difficult task. From a surveyor's perspective, surveyors can be asked to produce reports. And what I'm going to show you is a commentary from a dear friend of mine who's a county court judge specialising in boundary disputes. And one of the things he sort of banged the drum on, as far as I was concerned, was the need to tell practicing lawyers about the dangers of instructing a surveyor in connection with a boundary problem or a boundary identification issue. And the problem is this, that a surveyor's report with regard to a boundary issue could be fundamentally flawed in circumstances where the surveyor has been asked to produce a report on behalf of one of the parties to the dispute, current or potential. Because in those circumstances, all he or she is doing is producing an opinion, and that's all it ever is, on the basis of one side of the story. What my pal who's a judge was saying was, in a situation where he's been asked to decide a case relating to a boundary dispute, where a surveyor's report is produced for him, that's been produced by that surveyor in order to assist one of the parties, that report is immediately discounted. What the judge requires is a report being produced by a surveyor that is an opinion, and we'll come back to that point in a moment, but is an opinion for the benefit of the court or an arbitrator. So again, let's just have a look a little more at this. My pal produced a 7-point guide on dealing with boundaries. And his starting point always is start with the operative conveyance, the document that created the boundary. So that might be registered title, it might be pre-registration title deeds, it might be whatever, but we need to find the document that created the boundary in the first place. If we can't find it, then there's a best evidence rule. What other evidence is there out there that reveals what was intended when this boundary was created? And I think here we've got to be quite inventive to see what sort of information or documentation we can get. If we've got our source document or our other evidence that's our best evidence, then we have to scrutinize it and ask, can you reliably determine the position of the boundary from that document? Look at the description, look at the plan, look at any of the provisions within a conveyance and ask yourself, can I from this identify what was intended when this boundary was created? As far as plans are concerned, if a plan is consistent with the description, that's a positive. And again, the plan can be utilized to support the description. Where it isn't, then we've got to look at the wording that's used, the operative wording that's used relating to the plan. And where the plan and description are inconsistent, then the general position is the court will value neither in excess of the value of the other, but will look at the actual locus, the site, and the boundary that's in dispute and try and determine which of the two makes the most sense. Words for the such as for the purposes of identification, or words describe a plan as being more particularly delineated, or a boundary being more particularly delineated by reference to a plan, do carry some weight, but will only carry weight if description and plan are consistent with one another. Point 3. If we can't find that source document, use extrinsic evidence. Physical features on the ground at the time the conveyance was created: a stream, a hedge, a fence, a wall. Look at maps, plans, photographs, estate agents' particulars, as well as affidavits, witness statements, or whatever it might be. And this is an interesting thing that I hadn't thought about. Look at post-conveyance conduct, if it's of value to assess what was intended. Performance of covenants or descriptions of land that's benefiting or burdened by covenant or easements in conveyancing, in a conveyance. Subsequent conveyancing procedures and processes, contracts, leases, etc., licenses, etc., and subsequent boundary features. Has anything been put in the way of the boundary that is an indicator as to where the boundary could be? Point 4. Evidential presumptions. There are loads of legal presumptions that I'm sure you will be familiar with from law school. The hedge and ditch presumption, the ownership of a road. If you own land butting a highway, you own to the centre of the highway, etc., etc. There is a Land Registry Practice Guide 40 Supplement 3 in England and Wales that assists. There isn't an equivalent in Northern Ireland, but the important point to share with you this afternoon is that these presumptions are always capable of rebuttal. So if I can prove that the hedge and a ditch were not planted and excavated at the same time, the hedge and ditch rule doesn't apply. I do lots of work for the Highway Authority, and there is a presumption that where there are two hedges and a highway, public highway, running between the two, the extent of the highway is all the land between the two hedges. Well, the important point to appreciate here is that rule only applies, that presumption only applies, if you can prove that the hedges were planted at the point the road was created, the surface was metalled, or the road was constructed. So again, be careful with presumptions. Point 4. Point 5, where if we do and we are lucky enough to find a conveyance that creates the boundary, then we've got to construe the conveyance. We've got to interpret it. What does it mean? And I think this third bullet point on this point, I think, is really useful. We've got to look at the conveyance against the background of its surrounding circumstances and ask ourselves where a reasonable purchaser, looking at the evidence of the actual and known physical condition of the land at the date of conveyancing and looking at any plan that was produced at the time, where would they think the boundary would be? This is taken from a Court of Appeal decision called Pennock against Hodgson. The judge in that case was Lord Justice Mummery, that produced a really useful heading in his judgment, how to construe a conveyance. And there's another case, ACO Properties against Seven, 2011, where the judge in that case distilled what the Court of Appeal had said in Pennock and Hodgson and sort of reiterated it using different words. I'd commend both of those things to you. Point 6. You can't just say, a judge can't just say, I don't know. A legal boundary has to be somewhere. A legal boundary is a pencil line that separates one title from another and must exist. So if the court is being asked, or an arbitrator is being asked to identify a boundary, then the position is it must look at all available evidence and try and determine the line of the boundary. It can't have land that's conveyed, that's fuzzy at the edges. Nielsen and Poole and Judge McGarry, as he then was, authority for that proposition. And then point 7, something else to watch out for. Boundary agreements, adverse possession and proprietary estoppel can throw into the mix and generate utter confusion with regard to a boundary identification. Because then what we're looking at is not what was intended when the boundary was originally created, but we're looking at what is the position with regard to the boundary given the latest developments relating to the land in question. Has there been a boundary agreement? Has there been a claim for adverse possession? Has a proprietary estoppel been established? In which case, we're left with looking at the evidence that's been adduced in connection with those three issues to determine where the parties, where a court, where a third party now determines the boundary actually exists. On the point of boundary agreements, be aware that there's been a recent Court of Appeal decision that says a boundary agreement entered into between individuals is binding on them, but also binding on subsequent owners, if it is described as a demarcation or boundary agreement. That's this case of White against Alder, which I've mentioned on slide. Demarcation agreements are binding on subsequent owners, is the Court of Appeal's stance on that point. The next thing I want to talk about, and again, if someone wants to talk about something else, put it in the chat, please, but the next thing I want to talk about are restrictive covenants. And again, just to some basic points that I think are important. Are there restrictive covenants on the title? And if there are restrictive covenants on the title that our client is acquiring as part of the due diligence process, we've got to ask ourselves, are they going to impact on client objective? Can we ascertain if those covenants are enforceable, and if they are enforceable, by whom? And is a client aware of the fact that if there are restrictive covenants, it might be possible to buy out the covenant or to make application to vary or remove the covenant? And where there is a covenant that we think is enforceable, but we're not sure, we should ask ourselves, is defective title insurance appropriate? And in those circumstances, we should be talking to Robert about the availability of defective title insurance. On that latter point, before investigating enforceability of a restrictive covenant, where we are looking at taking out defective title insurance, we do need to be careful about undertaking any work that would disclose the existence of a defect or disclose the potential existence of a defective title insurance policy. So our scurrying or ferreting around trying to find whether a covenant is enforceable or not could mean that we can't actually obtain a defective title insurance policy in the future. It might be better not to carry out any investigation and simply obtain the policy right from the outset. When we're reporting on title with regard to restrictive covenants, again, we should be thinking about the provision of information, the existence of restrictive covenants, explanation, what are those covenants and do they impact on our client's objective, and advice. Are they enforceable or not? If they are enforceable, what steps or measures can be taken, particularly where our client is intent on doing something relating to their client objective that would be potentially mean that they would be encountering a breach of covenant. The giving of advice, the assessing of risk or issues in those circumstances. What if land is bought that benefits from a covenant? And again, here there's some important points to share with you. One, the client should be made aware of the fact they're buying property that appears to have the benefit of a restrictive covenant. The client should be told that the right to enforce that restrictive covenant could be lost. And here's an important point that I think lots of residential conveyancers miss. If I own land that has the benefit of a restrictive covenant, the best thing I can do if I become aware of breach is to seek an injunction. But the seeking of an injunction is the seeking of an equitable remedy, and therefore to do so, A, I have to have clean hands, and B, I need to be aware of the maxim that delay defeats equity. So if I'm aware of breach or potential breach of covenant and I sit on my hands and do nothing, I could lose the right to seek an injunction to stop whatever activity is intended. I would still be able to claim damages, but the point there is the damages that I'm likely to recover are going to be far less useful for me than stopping the breach. And again, on the issue of damages, I'm likely to receive compensation for the breach itself, nominal damages for the fact that the restrictive covenant has been breached, and also damages for disruption or disturbance that's caused or diminution in value of my land as a consequence of it being developed. But all of those heads of damage are likely not to generate a significant opportunity for damages to be awarded in my favour. Frequently, where there's a breach of covenant, what we want to do is to stop it. Delay, inaction, waiver or estoppel could mean our right to seek an injunction could be lost, and I think it's important that our client is aware of it. When creating restrictive covenants, there are three important points that I want to draw to your attention. One, we need to ensure that any restrictive covenant is properly protected. 2, that we clearly identify the land that's burdened by the covenant. And 3, and importantly, we need to identify the land that has the benefit of the covenant. And we need to understand and explain what could happen in the event of the land benefiting from the covenant being subdivided. So we need to deal with all of those things. And we need to make sure where we're drafting a restrictive covenant, is the covenant personal? Can the covenant be enforced and enforced against successors in title? There's a guy called Christopher Heather KC that specializes in sort of disputes and negligence claims concerning restrictive covenants. And one of the things he says is frequently omitted by someone drafting a covenant is the clear identification of the land that benefits from the covenant. Be aware of that potential problem. Where you're acting for someone who's buying land that's burdened by a covenant or land that has the benefit of the covenant, advise the client that it may be possible for the covenant to be bought out. It may be possible due to circumstances for the covenant to be unenforceable. It may be possible for an application to be made to vary or remove covenant at some point in the future. The last topic that I've got on my list today are issues associated with rights of way. And again, as a residential conveyancer, it is imperative that you advise clients to ensure, A, that whether highways to the front, rear or side of the property are adopted and footpaths are adopted, meaning they are maintainable at the public expense, and mean that your client has a right to pass and repass along footpaths and indeed roads at will. The fact that a property abuts a public highway does not entitle the client to park outside their property, but does give them a right to park on the public highway, provided they don't obstruct it. We need to be really careful where there are private roads or private pavements or rights of access to and from properties. One, we need to make sure that the easement that's granted, if it's an express easement, is granted in terms that are sufficiently wide to enable the use of the property being purchased to be properly enjoyed. We also need to make sure that the right of way is clearly identifiable, the route of the way, the points of access and egress, and the width of the right of way clearly identified. And importantly, we need to make sure that issues such as repair and maintenance and the cost of repair and maintenance are dealt with within the deed. So, acting for a buyer, what's our client's objective? Are there easements that are granted to facilitate that objective? Are there any easements reserved over the land that would preclude or limit that objective? Check the title. Buyer should always be told to inspect property being acquired in case there are prescriptive rights that would be enforceable against the buyer, even though not recorded on the title. If we're acting for a seller, remember the seller would be obliged to disclose to a buyer any easements that are not obvious on inspection and not recorded on the title, on the basis that they are overriding interests. So again, the seller needs to be aware of that duty, and if you're acting in connection with the sale, you need to audit the title to check the position. Prescriptive easements are binding on the owner of the land if the land is unregistered. If the land is registered, then they need to be protected by some form of registration. And creating new rights of way, express grant of a legal easement is the ideal way. Implied due to necessity or an intention would be an issue that could apply in connection with Northern Ireland, as would be acquisition by prescription. The important point with regard to acquisition by prescription is that the easement, the right of way, is a right of way for the historical use. So just because we've got a right of pedestrian access established by prescription to take our refuse bins from our property across a neighbouring garden to the public highway every Tuesday, that would not mean that that right would be a right of way on foot for all purposes and at all times. It is a prescriptive right to take refuse bins from the property that has the benefit of the easement across the land that's burdened by the easement to the public highway. And this change of use or an intensification of development of the benefiting land does not automatically intensify or change the right that was acquired by prescription. So, are there rights of access and egress to the property? How are those rights protected? Is the legal and physical extent of the right of way clear? And what about repair and maintenance issues? There's a High Court decision called Carter against Quayle that sets out what the position is if a right of way is silent. In essence, the person that has the benefit of the right-of-way, or who owns the land that has the benefit of the right-of-way, has the right to repair and maintain it, but does not have the right to transmit or costs or share costs with adjoining landowners. So any right-of-way needs to deal with those issues. And watch out for back lanes or paths in an urban context, and watch out for rights-of-way issues generally in a residential context. When creating a new right-of-way, describe the route as well as depicting it on a plan. Make sure the two are consistent with one another. Make sure that we look at the client objective. Why is the right-of-way being granted? And does the owner of the land burdened by the right-of-way require some protection? Are we going to identify points of access and egress? And are we going to think about future land use in connection with burdened land and benefiting land? And what about improving the right-of-way or repair and maintenance? Are we making express provision for that? Do watch out. I've seen this in a matter in Northern Ireland and in the United Kingdom, both Scotland and England. A situation is if you have a right-of-way to field A and then you acquire field B, the right-of-way to field A does not automatically extend to field B, even though you can access field B via field A. And very important that you're aware of that. It catches people out on a regular basis. Common law position on repair and maintenance is ascertained in a case called Carter and Cole. The owner of the burdened land is not obliged to construct a right-of-way unless the deed specifies. The owner of the land that has the benefit of the right-of-way may construct a right-of-way if it hasn't been constructed, and can access land adjoining for that purpose as long as he or she makes good any damage that's occasioned. Anyone using the right-of-way can repair and maintain it, but as I repeat, is not entitled to recover costs from third parties, and therefore you would need to revise the common law position where you're creating a right-of-way. The other interesting thing on that, just as I remember, is if you have a right-of-way to a parcel of land but no facility to park on the land that has the benefit of the right-of-way, the right-of-way will include a right to park on the way as long as you don't obstruct it. Scottish case called Moncrief and Jameson decided in the House of Lords, authority for that proposition. Can you abandon rights of way? I was asked about this question last week. Difficult, if not impossible, to establish. Just because you can't use it, just because you haven't used it, would not mean it's abandoned. Abandonment involves the owner of the dominant land showing a fixed intent never to usurp the right in the future, normally in the form of a deed. Lack of use is not enough, and you need to proceed with caution as a consequence. I've seen lots of nightmares where someone has assumed that a right-of-way hasn't been exercised for the last 50 years and therefore it no longer exists. That is not the case, so caution is required. Some of the issues I've talked about today indicate the availability of Stewart title products. So all we've done here, or Robert has kindly done, is just shown that there is defective title insurance in connection with all of these issues, including, of course, lots of bespoke policies and their online facility. So if anyone is interested in taking out defective title insurance for any of the issues I've explored today, do talk to Robert in connection with those issues. His contact details are, if I can find the slide, I'll have to go back to the beginning and find it for you. Just bear with me. Sorry about this. I thought it was right at the end, but it isn't. There you are. Robert Kelly's email address. Does anyone have any questions or queries? Has today been useful? I don't want to be a sort of the conveyor of gloom and doom, as it were. What I do want to do is just indicate to you potential for risk and claims, and just highlight to you what I think are important developments as far as the legal profession is concerned. A few things. We are trying to organise a conference in Belfast at some point in 2026. We'll keep you informed. If you have any topics that you'd like us to explore, or speakers that you would like to come along and attend these forums, drop either myself or Stewart Title a note and we'll gladly organise it. But in the meantime, massive thank you to everyone attending today. Has it been of some benefit? So can I ask Richard, Helen, David, anyone else attending, Mark, whether or not the topics that I've chosen are of some interest? Are there any topics that you would like us to look at next time around? What I'm intending to do is to find some interesting Northern Irish cases, and there's loads of them on all sorts of different topics. But if anyone has a burning issue or a burning problem with searches, with regard to due diligence, with regard to the Law Society of Northern Ireland and any obligations being imposed on you with regards to risk assessment, compliance issues, anything like that, let us know. We can talk about that next time. But subject to that, as time is sort of catching up with us, all I would like to do is, Robert, once again, thank you and wish you well with regard to your flu. To everyone else, thank you for your time and giving up your time today. To remind you of the AI webinar on Thursday, and Robert will provide you with details so you can come along to that. And to ask you if you have any questions or queries, to drop me a note via my email address, which I'll put up as the last slide, and we'll endeavour to incorporate questions or queries in our next forum. But on that happy note, thank you very much indeed for attending today. Stay safe, and I hope you have a good day and a good week. Thanks, everyone. Thanks, Robert. Get well soon. Thanks, everyone else. Speak soon. Thank you. Bye-bye.